Think about it. Every single day in India, millions of contracts get signed. But what happens when things go sideways? Most of us, we think of courts. But there's this powerful alternative, a kind of private courtroom called arbitration. But that gets to the real heart of the matter. Are some disputes just too important, too fundamental to be settled behind closed doors? We're about to dive into how India tries to draw that very, very fine line between what can be handled privately and what absolutely must be decided in a public court.
So, why the big push for something other than the courts? Well, this quote from a Supreme Court justice really says it all. It paints this incredibly vivid picture of the old system. It was seen as agonizingly slow, impossibly complex, and just way too expensive. It was a system that was practically begging for a solution. And for a lot of people, arbitration was supposed to be the answer.
All right, so here's what we're going to cover in this explainer. First, we'll look at the big promise of arbitration. Then we'll get into the core question, what's actually off limits? From there, we'll break down the landmark Booz-Allen test that tried to sort all this out, see where that test started to run into trouble in the real world, and finally, look at the big push to rebuild the rulebook from the ground up.
So, to get away from that broken system, India really embraced arbitration, especially as its economy started opening up back in the 1990s. The goal was pretty simple. Let's create an alternative to the courts that's actually effective and efficient. For international businesses and investors, this wasn't just a nice-to-have. It was absolutely non-negotiable. They needed a dependable way to sort out commercial disputes without getting stuck in legal battles for years and years. Arbitration promised to be exactly that.
Okay, so arbitration sounds pretty great, right? Fast, efficient, business-friendly. But if it's so good, why can't we just use it for everything? Why are some fights still reserved only for the courts?
And that's the thing. The law itself didn't really have an answer. India's main arbitration law, the 1996 Act, was surprisingly quiet on what was in bounds and what was out. It created this huge legal vacuum, which meant the Indian courts had to step in and basically draw the map themselves, defining the very edges of private justice.
And there's a legal word for this whole idea, arbitrationability. You could think of it like a gatekeeper. It's the principle that decides if a dispute gets to go down the fast track of arbitration or if it has to line up and go through the traditional court system. Honestly, understanding this one word is the key to this whole puzzle.
So for years, things were kind of murky. But then, in 2011, this landmark Supreme Court case comes along. Booz, Allen, and Hamilton versus SBI Home Finance. This was it. This was the court's first huge attempt to bring some order to the chaos and create a real, definitive rulebook on what could and couldn't be arbitrated.
The court came up with this really clear three-part test. First, is the subject of the fight something that can even be arbitrated in the first place? Second, does the contract between the two sides actually say they can arbitrate it? And third, did they actually, formally send the dispute to arbitration? It seems simple enough, but that very first question, what is capable of being arbitrated, well, that changed everything.
So the court then specifically carved out 6 types of disputes that were totally off limits for arbitration. Things like criminal offenses, family issues like divorce, company bankruptcy, and fights over a will. The logic here was that these things affect more than just the people in the dispute. They touch on broader public policy, and they need the special authority that only a state court has. And this really gets to the heart of the whole test. The court essentially sorted rights into 2 different buckets. You have rights in personam, which are private. They only affect specific people, like a simple breach of contract. Those are totally arbitrable. But then you have rights in rem. These are public. They affect everyone, the world at large, like declaring who officially owns a piece of property. Those, the court said, have to stay in public courts.
All right, so for a while, it seemed like we had a solid rule book. The Booz-Allen test was the gold standard. But, the law is never that simple. The messiness of the real world quickly started to poke holes in this nice, neat framework, and it revealed all these gray areas that the original test just didn't account for. Let's look at how this thing started to crack under pressure. And the first big test case, it had to do with trusts. Now, on one hand, a trust is a private agreement, but on the other, they're governed by a whole law, the Indian Trusts Act, that spells out exactly how they should work. So could people just decide to ignore that and go to arbitration instead? Well, the Supreme Court came back with a firm no. The thinking was that the Trust Act was already a complete code all by itself, and it offered specific solutions that only a civil court could provide. And just like that, a 7th category was added to the Do Not Arbitrate list.
Okay, next up is the really thorny issue of fraud. This has always been a battleground.
I mean, is fraud just a private disagreement between two parties? Or is it something more serious, a kind of public wrong, that really demands the intense scrutiny of a formal court?
So the court tried to walk this really fine line. It basically said that, okay, simple allegations of fraud within a contract, an arbitrator can handle that. But if the fraud allegations are serious, complex, and have a public element to them, well, then you need the power of a real court to dig into the evidence. This created a new distinction that was, let's say, a little bit subjective.
And then there's intellectual property, like copyrights. Now, think back to what we just talked about. A copyright is a right against the whole world, a classic right in rem. So, following the Booz Allen logic, any fight over a copyright should automatically be off-limits for arbitration, right?
But this is where things got really interesting, and the thinking started to shift. The courts began looking not just at the general topic, but at the specific remedy a person was asking for. So a case to decide who truly owns a copyright, that affects everyone, so no, not arbitrable. But a simple contract dispute over royalty payments, that's a private matter, and yes, that is arbitrable. You can see how this was creating a pretty confusing situation, and it just proved that a clearer, more consistent rule book was desperately needed.
So with all these different exceptions and new interpretations popping up, it became pretty clear that just patching up the old rules wasn't going to cut it. The system needed a fundamental overhaul to bring back the certainty and predictability that arbitration was supposed to deliver in the first place. And that big overhaul really kicked off with the Law Commission of India's 246th report in 2014. This was a massive turning point, a really deep, systematic review of the entire Arbitration Act designed to fix all the problems that had been piling up for almost 20 years.
And the goals of this report were super clear. It wanted to cut down on the rising costs and delays that had started to creep back into arbitration, stop courts from interfering so much in the process, and get some real, solid legal answers for those tricky issues like fraud. It also made a big push for institutional arbitration, using established organizations to manage the whole thing and to make sure arbitrators were totally neutral.
You know, when you step back and look at the whole picture, it's a really fascinating story. India started with this struggling court system, so it jumped on arbitration for its efficiency. But that very efficiency created a new problem. How do you protect the public's interest? So then you had the court spending a decade building rules only to see those rules get stretched to their limits, which then forced a huge push to write all those hard lessons into law for the future. What India's whole journey really shows us is that this line between private speed and public justice isn't set in stone. It's a constant negotiation. And that brings us to one last big question. Is a perfect balance even possible? Or is this always going to be a moving target, constantly being redrawn by new kinds of disputes, new technologies, and our own changing ideas about what justice really means?